Hi guys, it's Kathy. I hope you're doing well. So we stopped yesterday. I'm at 1.25. Speed is good. We stopped yesterday right at the beginning of this video. It's the end of March 5th. And he's in mid-sentence when they start the video. So who knows what he said before that, but it's fine if we miss a part of a sentence because we've heard a lot of freaking sentences.
And the degradation simply means the little pieces of DNA are kind of breaking up, and
Wow, that
you lose the
sounds
ability to
so
detect them.
fast.
Beyond the scope, Your Honor.
Nope.
And if hypothetically blood from person B gets put on that swatch later on after A has started to break down, then you might get the hypothetical that's up on the projector.
Beyond the scope.
It's an improper hypothetical. Sustain.
Now, Mr. Matheson, I want to ask you a couple of questions about the EAP testimony that you gave on redirect. You recall Mr. Goldberg asked you specific questions about the articles that I had referred you to. You remember that?
Yes, I do.
Now, let me ask you first of all, the only article that you referred to on direct was the Zajac, Bloombaum, and Krim article, correct?
That was
relevant, Your Honor.
Oh, that was the only one presented to me. Yes.
Now, let me show you that article. Have you read that recently?
I've read this, and yes, it's been within the last several days.
And you've given testimony on redirect about the manner of degradation of an EAP, have you not?
Yes, I have.
I'm sorry, of a BA.
That's correct.
Would you agree that that particular article that you referred to, nowhere in it talks about how a BA degrades in terms of what happens to the bands, does it?
Did you ask whether or not that makes any reference to any form of specific type of degradation?
No, my question is, it doesn't tell you which bands you lose in what order when you degrade a BA, does it?
No, it does not.
We have slide C.
See.
Now, you recall yesterday we had a slide similar to this to illustrate the path of degradation of a BA down to a B, correct?
It had similarities to this, yes.
Now, one article that you were shown by or asked about by Mr. Goldberg on redirect was the Yeshian article. Remember that?
Yes.
And you testified that article said nothing about the manner in which a BA degrades in terms of which bands disappear first. You remember that?
State's testimony.
Rephrase the question.
You recall testifying that that article did not describe the path of degradation of a BA.
No, the state's testimony.
Well, from my understanding of the articles, I believe it describes a different, the focus of the article is a different degradation, the B to a CB or something like that.
Okay, let me show you that article. I ask you to read first paragraph under discussion.
Okay, under discussion, it says several studies on.
Just read it to yourself.
Oh, I'm sorry. Okay.
And that article does describe the path of degradation in terms of which bands disappear first, doesn't it?
It does have a two-line reference to it, yes.
And it refers to that as being an analysis of other literature on the topic, correct?
It references several studies, yes.
And it says that all of those studies describe the path of degradation the way I did on my cross-examination with you, correct?
Yes, it does.
Not the way you described it, correct?
Well, Mr. Matheson did describe it in one way.
Sustained.
Not the way you described it as leading to 2B bands, correct?
That's correct.
Now, you were asked a question about the book that you had referred to, the Saperstein book. You recall that?
Yes, I do.
And the chapter of that book that you were referring to is actually written by Dr. Sensabaugh, correct?
Yes, I believe we
And
mentioned that.
I'm sorry. And he's the same author that of the article that I provided to you. during cross-examination, correct?
That's correct.
And that article, the portion that you read from that article describes one other possible path of degradation for a BA, correct?
I think gave indication of that, yes.
And could you read again starting at the thus, which you read yesterday, and read down to, where it says two.
Where it says what?
The next sentence where it starts with two.
Oh, okay. Am I reading this one out loud?
Sure.
Thus, one might expect the A bands in BA and CA types to be lost before the B or C bands are lost, and this, in fact, has been observed. That's the end of the sentence. Okay. In typing aged type BA bloodstains, for example, only the major B band, and then in parentheses, the anodal B band, may be apparent, and the temptation would be to type the sample as a B type.
And would you agree that what that says is that you might also get a path of degradation that leads you to just seeing the B2 band and nothing else?
Yes.
And then the next part of that says what?
Since it has been observed that in aged BA bloodstains, the slow B band is generally lost before the fast A band, the controlling rule is to withhold judgment on a putative B type until both B bands are apparent. If the sample is in fact a BA type, the major A band should be apparent by that time.
Would you agree that what that says is that if you have both B bands, B1 and B2, that cannot be a degraded BA?
No, I believe it says things like generally and should. It's not an absolute.
Can you cite me to a single scientific reference that says that a BA can degrade to the point where you have two B bands and nothing else?
No, I cannot.
We go to slide D, please. Now, the EAP test measures an enzyme in the blood, correct?
Yes, it does.
And it's an enzyme that's found in red blood cells, correct?
That's correct.
And our blood is made up of red blood cells and other types of cells, correct?
Beyond the scope.
Yes,
And there's no DNA in a red blood cell, correct?
that's correct.
Our DNA is found in cells other than red blood cells, correct?
Yes,
So if you're doing a DNA test on a biological fluid that contains a lot of cells, you're only looking at what's in cells other than red blood cells, correct?
for the DNA, yes.
If we go to slide E. Now, Mr. Matheson, would you agree that our hands and fingernails are made up of cells?
Yes, they are.
And would you agree that if you took scrapings from under a person's fingernails, you would expect their DNA to be in it, wouldn't you?
Their own DNA?
Yes.
If you scraped and picked up some of their skin or blood or whatever happened to be under there.
And if you did that kind of a scraping where you got cellular material from under the fingernails, if you didn't find the person's DNA, that would be unusual, wouldn't it?
Beyond the scope.
Well, I haven't done DNA typing under fingernails, so I don't know if it'd be unusual or not.
Now, you could also, could you not, let's assume hypothetically that you have a person with fingernails that scratches somebody else who has an EAP type B. Have that hypothetical in mind?
Yes,
And a small amount of that, a person B who has an EAP type B gets under the fingernails of person A. You with me so far?
think so.
And you took scrapings from under the fingernails and did a series of tests on them. Would you agree that when you do the EAP test, you're going to detect the EAP type B from the person who was scratched, correct?
If there's sufficient blood present, the detectability limit of the test.
Now, would you also agree that if you had a greater amount of material, cellular material from person A, and you did a DNA test, that you would detect the DNA of person A in that mixture, wouldn't you?
If there's sufficient amount, yes.
And if the amount of DNA from person A overwhelmed the amount of DNA that might have come from the small amount of blood from person B, you'd never see person B, would you?
It's beyond the scope. It's getting into DNA.
Do you understand the question?
Yes. If the quantity of DNA provided by the tissue that was scraped was significantly higher than or sufficiently higher than the blood providing the AP, then yes.
And would you agree that you can do as many DNA tests as you want on that mixture, and you're never going to be able to prove that person B
Sustained.
isn't there?
Sustained.
I'd ask the jury to be admonished to disregard the import of that question.
They know that when I sustain an objection, that's the rule.
Now, Mr. Matheson, you talked about your control study that you used item 42 for, correct? Remember that?
I was saying that we did type item number 42, yes.
And I think you indicated that according to the article by Dr. Bedoli, that for that kind of control study to have any value at all, the sample that you're comparing it to has to have been subjected to the same myriad of environmental insults, I think is the way you describe it, correct?
I believe on reading that, it made reference to the fact that a blood sample collected from an area where the victim is, that's known to be the victim's blood, would tend to be involved in the same environmental conditions.
But if your control sample, in this case 42 that you testified to about, was subjected to different environmental conditions than the fingernail samples, your control makes no sense. It doesn't work that way, does it?
It's argumentative. It states
Same.
facts argumentative.
Rephrase the question.
In my example, the control is not a proper control, is it? If it's not, if that sample is subjected to different conditions than the one you're comparing it to.
Overruled.
Well, it still is going to provide information. It is blood that you know to come from a particular person. If the environmental conditions are not exactly the same, then that is something that might be considered.
Now, you were asking questions on redirect about wet stains versus dry stains. Remember that?
I think there was some mention of it regarding the studies, yes.
Incidentally, is there a single reference in the literature or a single study that you can point to that says that the degradation pattern of a wet stain is going to be different than a dry stain?
Not that I can recall at the moment.
Now, would you also agree that 84, the fingernails in this case, there were two samples, one from one hand, one from the other, correct?
That's correct.
And one of those samples appeared to be damp because you could see the transfer of material onto the container it was put in, correct?
Yes.
The other one was dry, wasn't it?
Well, the other one appeared to be drier. It had chunks of blood down the bottom, but the tip of the stick was a little damp, or a little red, which may indicate that it had a little bit of dampness in it, but there was a difference.
There was a difference in the conditions of those two samples, wasn't there?
No, vague, no robust conditions, also
Sustained.
speculation.
Sustained.
Would you agree that if your theory, if your testimony about a control study is accurate, it would only apply to samples that had the same conditions, similar conditions?
Vague is dissimilar.
Overruled.
I think that has to be taken into consideration, but there's still information that can be obtained.
Now, I would like to show on the Elmo I'm not sure what exhibit this is. This is the one that the prosecution did where they printed out with the arrows on it. Remember yesterday you were asked to identify I think you described them as band-like appearances
Yes.
from 42. Show you this, just refresh your memory.
Well, let's find out what exhibit it is first.
And then I put the number on that, something on it. That may be 244C.
Right.
Let me show you 224C on the Elmo.
Why don't we give Mr. Matheson the other copy of that?
Sure.
And keeping in mind time limitations.
Yes. Almost done.
Since when do we have any sort of time limitation, Judge? Judge, we haven't even talked about the murders yet, and it's been 17 months.
Mr. Blazer.
I'm going
Now,
to get
Ms. Rasmussen,
coffee.
you
Be
recall
right
that
back.
You had two arrows put where you saw what you described as something kind of like a band. Remember that?
Yes.
Now, you also testified during cross that there is something kind of like a band or something that you can see between those two arrows, correct?
That misstates the testimony. It's also conjunctive.
Overruled.
There is kind of a haze in that area. It's brighter than the background, yes.
And could you direct get an arrow put on that where you see that?
You need to go to the left. Left.
Can we cut the arrow at the same time, please?
How about if we have it on opposite sides of the same lane so that we can determine who put what where?
Okay.
Guess you need to go down a little bit. Down. Right kind of in that area off to the left there. There's kind of a hazy cloud of something.
Okay, let's click that. Now, that is in an area that would correspond to an A band, correct?
General area, yes.
Now I want to cover up everything except that lane. Matt's I'm going to cover up everything except that lane. See that?
Yes, I do.
And the technique I'm using is what you described earlier as reading it blind, correct?
No, actually, reading blind, that I mentioned before, is not having any information about the case. It's very difficult and really fairly inappropriate to read a plate without the controls and things present.
There's nothing on there that you, as a forensic scientist, will call a band, is there?
This is improper, Your Honor. This is not a scientifically correct way of doing it, and also the resolution's not doing that.
Sustain. Foundation.
Is there anything you would call, as a forensic scientist, under your training, that you would call a band?
Same foundational problems,
Overruled.
and the resolution's not good enough.
Overruled.
I don't believe I've ever testified that I identified bands in that lane, but that there were things or band-like visible areas that were showing up.
Including in the area of an A band, correct?
In addition to other areas of that lane, yes.
And would you agree that your band-like appearances are 3 areas of some sort of a cloudy thing that you've described, correct?
There's no foundation for this, Your Honor. It's also vague, it's a cloudy thing, it's an accident answer.
Overruled.
I'm sorry, could you repeat the question?
Yes. You testified now that you see 3 band-like things,
That mistakes the
That mis-
evidence.
That does.
that you see 3 areas on there that have a cloudy-like substance, correct?
That mistakes the evidence.
What do you see, Mr. Matheson?
I see areas on there of different intensities of a cloud-like type of appearance.
And that doesn't look anything at all like what you found on the fingernails, does it?
Well, that's an improper hypothetical.
No, it's argumentative the way it's phrased.
It's also a picture of a picture.
Sustain.
That doesn't look like what you found on the fingernails, does it?
Argumentative, Your Honor.
Sustain.
Does that look like the bands? Does that have the similar appearance to the bands that you found under the fingernails?
Argumentative, Your Honor. Improper hypothetical.
Overruled.
No, it doesn't. If it looked the same, I would have called this with the same result, and I didn't.
All right, let's move on.
Can we have slide, let me, Mr. Matheson, California Association of Criminalists has a code of ethics, do they not?
Yes, we do.
I want you to look at that and read the highlighted paragraph to yourself.
Your Honor, this is relevant, calls for hearsay.
Overruled.
Okay.
And you agree that those highlighted paragraphs are 2 paragraphs from the code of ethics from the California Association of Criminalists?
Yes, I do.
And you are a member of that organization?
Yes, I am.
And you consider yourself to be bound by those ethics?
Yes.
And I'm wondering if we should print out a copy of that last demo I did.
Your Honor, I object to that because there was no foundation for a scientist looking at something that's covered up like that.
Overruled.
Can we have slide F, please?
Let's proceed with a little alacrity.
Mr. Matheson, would you agree that code of ethics of your organization that you are a member of provide that the criminalist will be alert to recognize the significance of a test result as it may relate to the investigative aspects of a case? In this, I'm sorry, I got it backwards. Let me read the other one. Would you agree that one of those provisions provides that where test results are capable of being interpreted to the advantage of either side of a case, the criminalist will not choose that interpretation favoring the side which he is employed merely as a means of justifying his employment? Do you agree that that's one of the provisions of your code of ethics?
Yes, I do.
Could we see the next slide, please? You also agree that one of the provisions of your code of ethics is that the criminalist will be alert to recognize the significance of a test result as it may relate to the investigative aspects of a case. In this respect, he will, however, scrupulously avoid confusing scientific fact with investigative theory in his interpretations. You agree that that's one of the provisions of your code of ethics?
Yes, I do.
And you agree that there is no scientific support for your testimony that a BA can degrade to the point where you have 2 B bands remaining?
No, I do not.
Isn't that what you're doing in this case, Mr. Matheson, is violating this code of ethics?
Your Honor, this is totally
Sustained.
argumentative.
Sustain.
I have no further questions.
Mr. Goldberg.
He's literally asking the same questions he was asking when I went to get my cup of coffee. And I brewed it and I cleaned a few dishes while I was out there because I was waiting for my coffee. And same question.
Mr. Matheson, you are, as a criminalist, bound by a code of ethics. Is that correct?
I am bound to one of the organization that I belong to, and personally, yes.
And does that code of ethics also have provision dealing with presenting inconclusive results in court?
As far as they would not be,
No, the circumstances under which you are allowed to present those results. Thought we looked at that yesterday, didn't we?
I'd have to review and find out what the
Can you
provision
take
is.
Can you take a look and see it? Yeah, folks?
Please. See if we can speed this up just a little.
Well, they can't slow it down. This child is still faster than my kids were getting ready for school.
Okay. Looking at paragraph 2E. Sir, can you read that for us?
It read, excuse me. It reads, where test results are inconclusive or indefinite, any conclusion drawn shall be fully explained.
And when we were talking about the inconclusive results in this case, in terms of the EAP issue, did you explain at exhaustive length how you were considering and why you were considering those results?
Yes, I believe so.
Did you feel that it was necessary to do so?
Yes.
Why? Even at the risk of perhaps boring and presenting maybe marginally relevant explanations at the length to which you went to explain them.
Well, they needed greater explanation than the conclusive results because they are inconclusive. A conclusive result is a final statement. In conclusion requires that some sort of explanation be made.
And at all times throughout your involvement in this case, have you scrupulously followed the ethical standards and guidelines that you are bound to follow as a criminalist?
I always follow them to the best of my ability.
Sir, do you consider your participation in the California Association of Criminalists to be important?
Yes, I do.
And do you consider your job as a criminalist to be simply a 9 to 5 type job, so to speak, or does it mean more than that to you?
No, it means a lot more. It's a profession. That's why I'm involved in the associations and the profession as a whole.
And this code of ethics comes from the California Association of Criminalists?
Yes, it does.
And you are one of the former past presidents of that organization, is that correct?
That's correct.
And sir, can you tell us what the little lapel pin on your lapel represents?
That it's a pin of the California Association of Criminalists.
And have you at any time ever tried to interpret or misinterpret a result in this case, or any of your testimony in this case, to favor the defense?
Sustain. Raise the question.
Have you ever tried to present any testimony in this case in such a way as to favor one side or the other?
No, I have not.
And since you have been testifying, has any member of the California Association of Criminalists called you and criticized anything that you've said?
It's irrelevant.
Now, Mr. Matheson, I'd like to ask you a few other questions quickly about the EAP issue. I know we've gone into it at exhaustive length, but we'll make it very rapid. As to the Yashan article that you were asked about, was that an article that studied in the sense of doing experiments on the issue of EAP degradation from BA to B?
No, it is not.
Okay. What type of EAP degradation issue was Yashan dealing with?
It was a technical note about a B to a CB.
Okay, so there's some other degradation problems that deal with EAP that we haven't really discussed at length in this case. Is that correct?
That's correct.
Oh, we've covered this once already.
And Mr. Matheson, scientifically speaking, does this article, the Yashan article, provide any new scientific information in terms of a study on the BA to B phenomena?
No, it does not.
Now, with respect to the Grunbaum study that we talked about, was there a sample in that study that was in fact mistyped as a B question mark that was a BA?
Yes, there was.
And did Mr. Grunbaum state that in those cases, distinct band patterns were present in the cases of the mistypes that occurred in his study?
I believe so, yes.
What does that mean?
Well, I think the use of the term patterns rather than pattern indicates more than one band.
And you have stated that in your professional career, the BA to B phenomena is something that you have personally seen where there are both B bands present.
Yes.
And that includes a number of instances in this case. Is that correct?
Related to this case or other cases?
Well, there are a couple instances in this case, more than one, where you believe it happened here.
Yes.
Now, you were asked about preconceived notions and the effect that that has on a scientist's judgment. When you were typing 42, the pool of blood of Nicole Simpson, had you previously been informed prior to when you did your work by Mr. Fung that that was collected as a sample of Nicole Brown's blood?
Objection calls for hearsay.
Coming in for the state of mind on preconceptions.
It was my understanding that that's what that sample was.
And that's what you believed when you were actually doing the testing.
Yes.
So when you were actually doing the testing, did you believe that the result should be a BA?
Objection. Argumentative. Asked and answered.
It's leading.
What did you believe the result should be prior to doing your test?
I was expecting to see a BA.
And is that what you saw?
No.
What did you see?
I saw an inconclusive result with some kind of fuzzy areas that lined up with the two B bands.
So
Excuse me, B bands.
you called it as a B inconclusive.
B question mark, and the conclusion was that it was inconclusive.
And sir, did your preconceptions in any way affect that result or that notation in your reports?
No, it did not.
In the literature, have you seen a single reference that says that the only degradation route is the one that was discussed in the article by Raxall under all conditions?
Not that I recall, no.
And has anything that was brought up to you on cross-examination with respect to the EAP issue, excuse me, on recross, caused you to reevaluate or reform any of the opinions that you've presented here in court on the EAP issue?
No, it is not.
Now, on the card key system, you were asked about the computer system and dealing with evidence tracking and the card key system dealing with the doors. Are those two separate systems?
I'm sorry, will you repeat the question?
You have a computer system dealing with door entries, is that correct?
Yes,
And you have a system that also tracks evidence called the set system, is that correct?
that's correct.
Now, are those the same computer program or are they different computer programs or what?
They're totally unrelated and actually sit on totally different computers.
And was the card key system with respect to the laboratory, in fact, in operation from, let's say, June the 12th all the way forward to today?
Yes,
Do you know how much, do you have any personal knowledge of how much was in the blood vial at the time that it initially came to the laboratory?
no, I do not.
Now, with respect to the evidence processing room, is there any practice in place at SID to take detectives on tours of the laboratory and point out to them where everything is and where the drying cabinet is and the like?
We do occasionally give tours to detectives.
Is that done, though, for every single one systematically?
No, it isn't. If they express an interest, we'll be happy to show them around.
When you take tours, what do you make it a point? Well, have you ever done a tour yourself?
As far as giving one?
Yeah.
Yes.
What do you make it a point when you're giving a tour to point out the drying cabinet? This is where we dry our biological evidence.
Objection. Argumentative.
No, that's not one of the highlights of the tour.
Actually, the lab is set up for tours, isn't it?
Yes, it is. The windows into the lab, and we actually have an audio system where you can push a button and listen to a talk about that unit.
And with these windows, is that so that people can look inside the lab and see what's going on, and then they press a little button that gives them a description of it?
If they want to, yes.
And are these guided tours that you occasionally give to school children and the like?
Yes,
So they just go through the corridor area and they can press these buttons?
they can, yes.
All right. So if, when someone's working in the laboratory on evidence, say the serology laboratory, there's a window that's set up so that people can see in and watch what they're doing.
Yeah, most parts of the lab, you can't see into all corners of it.
Now, Have you ever seen, do you know whether Detective Van Adder, Detective Lang, or Detective Furman have ever had any tour of the SID facility?
I have no personal knowledge of that.
And have you ever seen either of those detectives trained in how to collect a swatch?
I don't remember if any of them have received direct training on that.
Have you ever seen them collect a swatch?
Not that I can recall.
Thank you. I think that may be just about it. I just have one moment, Your Honor. I think that that's just about it. Thank you very much, Mr. Matheson, and ladies and gentlemen.
Blazer?
Matheson, in the Grunbaum article that you testified to, where there's reference to one example of a BA degrading and being mistyped as a B, do you have any idea how many bands that degraded BA had?
Calls for speculation. Ask and answer.
Oh,
Not exactly, no.
You can't tell whether there were two bands at the end or one band, can you?
Not unless the term patterns makes reference to that, but not specifically, no.
You ever call Dr. Grunbaum or Mr. Zajac to ask them?
that's three.
No
That's
questions.
three. Thank you. Nothing more on that?
No, Your Honor.
All right, Mr. Matheson, thank you very much, sir. You are excused as a witness subject to being recalled.
Thank you.
All right, and don't discuss your testimony with anybody else with regards to this case. All right, ladies and gentlemen, we're going to take our recess for the morning session. Please remember all my admonitions to you. Don't discuss the case amongst yourselves. Don't form. You know what the admonition is. Don't discuss the case amongst yourselves. Don't form any opinions about the case. Don't allow anybody to communicate with you with regard to the case. Don't conduct any deliberations until the matter has been submitted to you. All right, we'll stand in recess as far as the jury is concerned. All right. And I'll see counsel in about 5 minutes. Good afternoon, counsel.
Good afternoon, Your Honor. Your Honor, the most precious commodity an advocate has is credibility. Before I walked into this courtroom, you and I didn't know each other, although we passed through the same halls of a law school in Northern California, but neither of us even remembered meeting each other. When I walked into this courtroom many months ago, a lot of things were said about, from the prosecution side, to, quote, inoculate you as to how I would conduct myself as a professional and how Mr. Neufeld would conduct himself as a professional. And during the course of these many months, as any advocate, I have to build up credibility with you. I have to be accurate in what I say. I have to comport myself in a manner that is in accordance with the rules of the court. I have to make representations to you factually again and again that are accurate for you to have any trust in me, a person you've never seen, have no experience before, never worked with before. The same is true, and I know the court realizes this as a trial lawyer, with a jury. When one gets up and conducts a cross-examination, the facts ought to be there. One has to be very careful in the representations one makes, in the points one makes. Advocacy should be vigorous, but it has to be fair. I think the term applies to prosecutors in United States versus Berger. Words I'm sure your court's familiar with. You have to strike, you can strike hard blows, but they've got to be fair ones. And I think the same applies to advocates on both sides of the aisle. So it's of great concern to any advocate to finish cross-examination that's been carefully planned when details have been gone over with the court, when one is relying on court orders, one is relying upon compliance with those court orders by the Scientific Investigation Division Laboratory, by the prosecutors, bases, in all fairness, certain lines of questions on those representations in compliance with this court's order. I think I'm entitled to rely on them doing their job diligently and making fair and honest representations. It's not too much to ask. I was set up. The record is now clear that first, when the discovery application was made for the production of original documents, mistakes were made by personnel in SID in turning over, according to them. I mean, let's just assume page 4 was the
What's
original.
going on?
According to them, they made
What
a
in the
mistake and
world?
did not turn over the original. I don't think there's any question now in terms of the record that they were very concerned about why we would be looking at these documents and what our concerns would be. And I think it's fair to say that they also knew we were very concerned about Mr. Simpson's blood file.
Well, Mr. Scheck, let's sort of cut to the chase.
Yeah.
We know that the court made the production order.
Yes.
We know that during the course of the testimony of Mr. Fung, that page 4 appeared. That appearance was known to the prosecution prior to the conclusion of your cross-examination, Mr. Fung. and that a decision was made, it was discussed and the decision was made not to reveal that prior to the redirect examination.
Missing one step. If I could bring court's
What one
attention.
step am I missing?
Between the time that I finished the cross-examination and during the production of documents, the record is clear that Mr. Hodgman notified Mr. Neufeld and myself that in the documents that they had turned over to us, one of the documents was not an original. That was the page that's been designated L16/32. And I outlined this with citations to the transcript in my letter. That came up in the cross-examination and, in fact, in the direct examination. It then became clear that before we proceeded down that last fatal line of cross-examination, that the prosecution, through Mr. Fung and Mr. Matheson, went into Mr. Fung's notebook and came out with the original L16/32. The reason that's significant, Your Honor, is it put them on notice that their original productions might have been inadequate. And also, and I find this very troubling, I'm sure the court noticed it, Mr. Goldberg, in all his arguments that I made some kind of tactical choice not to come forward and point out a mistake to them, misstated the facts to the court on the record, saying that we were the ones that brought to the prosecution's attention that we had not received an original, therefore we should have done it again with page 4, when exactly the opposite occurred. They brought Mr. Hodgman down to this courtroom when this issue was in dispute, and Mr. Hodgman said that we were correct. They then file this parity motion with the court and repeat the same inaccurate misrepresentation as to the chain of events. It's astonishing, and make the same argument.
Well, Mr. Scheck, I'm just,
No, the reason I focus on that,
I'm just trying to cut to the chase.
No, no.
Counsel,
Yeah.
I sat through all this.
I understand, and I know you know the record. The only reason I'm pointing this out and emphasizing it is that one of the problems I had with the proposed charge of the court is that it's my position that they had further notice, and this is not, the court referred to it an inadvertence, I think mistake in the first instance is a fair statement. SID made a mistake in turning over the documents, if you want to be charitable. They simply failed to turn over the right documents according to them. Then they're put on notice that where the mistake might have come from, and they didn't do anything about it. So I think there's another degree of certainly negligence or in terms of not being properly diligent in searching their files. And that's a factor to be considered in terms of what transpired subsequently to that. Now, I think the court was going to, that's the only reason I stopped the court. Now, think you want to cut to the chase and ask me another question about what prejudice?
No, I understand your argument about the need for trial counsel to maintain their credibility before the trier of fact. I understand that. I accept that argument as being a valid argument. The next question is, you have submitted to the court a proposed admonition to the jury. I indicated to you that I would probably give 85% of that, but I was uncertain about the last sentence to be taken into consideration as the credibility of that particular witness.
Well, I think now that what's clear is that subsequent to the act of intentional misconduct, the prosecution then tried to exploit that on the redirect examination by asking Mr. Fung questions that indicated that they had fully complied with their discovery obligations, that they didn't throw away documents or tear them up,
Right.
et cetera.
But Mr. Scheck, I sat through all of that.
I know. And you also indicated when I objected to it and asked for the admonition at that point again, that it was overreaching and it was improper vouching and they were trying to exploit the mistake. My problem is, Your Honor, this happened so long ago. And then they then tried to exploit it and then continued with the misrepresentations. My problem is this. Unless you're willing to say something strong, it's not worth doing at all.
Ms. Lewis,
Thank you, Your Honor. Good morning.
good afternoon.
Good afternoon, it is. Your Honor, let's look at some of the pertinent facts that haven't been highlighted. Initially, Mr. Scheck apparently was at SID and examined the originals, and I'm told there are some 80 to 100 documents that we're talking about. Examined those documents, felt at that time, we now know that there was a problem with the original not being present on page 4. Now, in that time, did he do what the defense has done consistently throughout this case, not only with the DNA labeled materials, but with every other type of material? Did he send us a letter? Did he call Mr. Hodgman? Did he do anything like that and say, did he even ask Mr. Goldberg there when Mr. Goldberg was present, do you know where the original page 4 is? It looks like it's missing. No, he didn't do that. And that was back in March. What he chose to do was to ask for all of these documents so that they could have a question documents examiner analyze them. We had no idea why they would want to do something like that. So we said, we think you ought to go to the court with that request, even though we have been complying with many, many requests of theirs that really go beyond the bounds of discovery. So they did. They went to the court, and what Mr. Scheck revealed to us during the last argument is that he made an in-camera ex parte, appropriately, offer of proof to the court, apparently, about this original of page 4. So apparently that is one reason why the court ordered the production of those originals from us to the defense for their inspection. All of this was unbeknownst to the prosecution. All we knew is that we were ordered to produce the originals, which comprised some 80 to 100 documents. We complied with the court's order to the best of our knowledge. The court already, I believe, made a finding that it was inadvertent that we had not turned over the original at that point in time. But what the defense apparently decided to do after their question documents examiner apparently verified that wasn't an original page 4. By the way, let's recall this is a blank piece of paper we're talking about, a blank form, which has just the typewriting but nothing filled in. Once their question document examiner apparently verified that wasn't an original, they, instead of once again asking us, as they have many times throughout this case on all sorts of discovery throughout this case, instead of asking us, do you know where the original is of page 4, according to Mr. Scheck, and apparently he just corroborated what it seems like now, he planned his entire cross-examination with culminating on this big finish of accusing Mr. Fung of being involved in a conspiracy by trying to cover up the timing with regard to the transfer of blood from Mr. Van Adder, Detective Van Adder, to Mr. Fung. So what counsel did was to make a deliberate tactical choice and maneuver to try and utilize this to exploit this nothing, as it turned out, to the benefit of the defense and making it appear like there was something there, that there was some part of a conspiracy there. None of this was known to the prosecution, of course. Now, we reached a point in time during the almost tail end of Mr. Scheck's cross-examination of Dennis Fung, and that's when he elected to come up with the accusations with regard to the missing original of page 4. And it became clear to the DAs at that time that he knew he didn't have the original page 4, and that's the first time that any of us knew that there wasn't an original page 4 examined by the defense. Now, one thing the court has stated which causes me concern, and I believe the record is clear, but I want the court to be clear in the court's mind, is that when Mr. Scheck had indeed finished
Yay,
his
Kelly,
cross-examination of the
thank
witness
you.
of
Yes.
Mr. Fung before we took a break. And it was during that recess that the attorneys involved sought to find out if indeed they could locate the original page 4. And, Your Honor, what Mr. Scheck said at transcript page 22776 is, Your Honor, I would like to do 2 more things, and I'm finished questioning this witness. What I would like to do is first have printed out on the Elmo a copy of the document with the erasure, different document, and then, in other words, the second thing, I would ask that each of these documents be handed to the jury so that they can examine them. Both of those items were done. The document.
They're cooked. They're cooked. They wouldn't have been. They made an honest mistake, whatever. Page 4 was missing, whatever. They're fine at that point. They're fine at that point. They find page 4. They are fine up until they all collectively talk about it and decide not to say anything. Now they say they don't say anything because the questioning is already over. The witness is about to leave the stand. It's too late to change anything. Doesn't matter. I don't think that matters.
It was collected back from the jury, and it reporter's transcript. Unfortunately, I have 2278, which has to be a page short, but within a few pages right after that, he said, I have no further questions. And at that point in time, the court took a
I did look, and there are sanctions in this trial. The attorneys, I'm not saying defense or I'm not saying prosecution. I'm just saying there are attorneys in this trial that had to pay money for sanctions.
recess. And so the record is clear that he had rested indeed before the recess. And at that point in time, the prosecutors looked to see if they could find where the original page 4 was, and they found it. Now, it was clear from the questioning that Mr. Scheck made of Mr. Fung that was a tactical decision on their part to handle it in that manner. Their remedy, now this was, Your Honor, discovery order that the court had made. The remedy for a discovery violation, well, the common sense thing,
Terry
which has
Love,
been done
thank
throughout
you
this
so
case
much.
by the defense, is to
I
come to us
really
and say,
appreciate it.
hey, we didn't get X discovery.
Kids love memberships. They're going to see that in their email any second now, and they're going to be so happy. Thank you, Terry.
On an informal basis. They could have done that, and they never did that at any point in time. The next thing they should have done would be to go to the court and say, we want a sanction of some kind. We want a hearing that, and on this missing original page 4. We want a hearing to determine if there's any impropriety on the DA's parts with regard to this original page 4. That was their remedy under the court's discovery order. Did they do that? No. They elected instead to use it in a tactical maneuver to seek to confront the witness with its absence. So what they did, and what's critical here, and what I don't believe we articulated last time we visited this issue, but what is critical, Your Honor, is that when the defense made that decision, they weighed.
Holy cow, I have never seen a gift membership hit that many regulars to the lives in one shot. That is amazing. Holy cow.
enforcement of the court's discovery order. They waived its enforcement by pursuing the course that they did rather than demanding an explanation or demanding an inquiry.
Do you know of any case authority that would characterize that situation or anything similar as a waiver?
I don't have a case, Your Honor. The Black's, we've cited in our brief the definition of waiver from Black's Law Dictionary, which really applies. I'd like to read it into the record. A waiver is defined as the intentional or voluntary relinquishment of a known right or such conduct as warrants an inference of the relinquishment of such right, or when one dispenses with the performance of something he is entitled to exact, or when one in possession of any right, whether conferred by law or by contract, with full knowledge of the material facts, does or forbears to do something, the doing of which, or the failure or forbearance to do which, is inconsistent with the right or his intention to rely upon it. Particularly that latter sentence, Your Honor, it's a lengthy definition, but the latter portion of it, when one in possession of any right, whether conferred by law or contract, with full knowledge of the material facts, which they had full knowledge of the material fact, does or forbears to do something, and they forebore to do, they forewent pursuing the appropriate remedy, which would be a discovery sanction and an inquiry of the court, and the court making inquiry of the prosecution to see if this was an intentional violation which warranted sanctions. They forewent doing that. And that's what this says. They do or forbear to do something, the doing of which or the failure or forbearance to do, which is inconsistent with the right, or intention to rely upon it. So their actions were indeed inconsistent with that right they had to that remedy under the discovery laws. And that was clear to us during the consultation, which went on during a brief 15-minute recess. It was clear to us, it was clear to the DAs involved, that they had elected not to pursue that avenue. They had indeed confronted the witness with it. Now, Your Honor, the Black's Law Dictionary in defining waiver is directly on point here. Now, I do want to make the point that the defense has apparently on more than one occasion attempted to make a mountain out of a molehill. And Judge, frankly, this wasn't even a molehill. This was a blank page, as the court has noted. There was nothing here. And it shows, frankly, how desperate the defense has been in some areas in coming up with a defense in this case. And it's demonstrated also by their shotgun defense. But I mean, this is just one example of where they have tried to make something out of really whole cloth. And instead of pursuing the honest, the normal, the truth-seeking, appropriate remedies under the discovery law, which the discovery laws encourage from both sides, they decided to try and use it as a tactical maneuver. And when they did that, it backfired and it blew up in their face. And they created their own problem by having done that. Now, I do want to make a point. When the prosecution, when Mr. Goldberg, who was brought into the case after the search and seizure had been litigated, when he inadvertently referred to the airline ticket and the baggage ticket, which was evidence which was only favorable to the defense, frankly, because it showed indeed that Mr. Simpson had a pre-planned trip to Chicago where he had apparently been. When they made a big deal of that, they made a big deal of it twice. And in the second instance, in fact, Mr. Goldberg, I believe, was admonished once. I don't recall exactly what happened the second time, but again, they made a big deal of that. And what did they end up doing? They ended up withdrawing their objection to 15 and 16. And initially, when they tried to do that, I think Mr. Scheck was the first to try and do that. And it appeared to me that Mr. Cochran didn't want to give that up as a possible avenue on appeal or something, whatever, to make more of. But they utilized that the most they could to try and dig a knife into Mr. Goldberg when he had really done, he had violated the court's previous order of which he was unaware. And it's too bad that it happens. I know he regrets that it happened. But it was certainly not, pardon? He was humiliated. He was indeed humiliated by the court and degraded because of that inadvertent good faith error that he made. So the defense now is seeking to capitalize on the court. You know, as the court knows, we as prosecutors are held to a very high standard, and we're often held to a higher standard. And right, and just to finish the point with regard to the airline ticket and the baggage ticket, they made it, I think I just made this point, but they made a big point about these documents and then later stipulated that they were admissible. So clearly, you know, where was the good faith in seeking to have Mr. Goldberg humiliated and sanctioned in front of the jury with regard to that? That just shows that that was game playing. Now, the point I was trying to make is we know as prosecutors that we are obliged to the highest standard under the law, and we do the best we can to fulfill our ethical obligations. We're also servants of the people of the state of California, and we're beholden to those people to be as vigorous advocates in favor of the truth and having the truth come out as we are allowed under the law and under our ethical obligations to be. And we have done that in this case, and we have consistently tried to uphold that integrity of the oath of our offices as prosecutors. And to have the defense turn around and try and blame our side of the table for something that their own tactical error caused them to be embarrassed by is just incomprehensible. It's not fair, Your Honor. It's not fair to the prosecution, and we should not be sanctioned. It's just not warranted. The one aspect that the court had expressed concern about, I believe, is satisfied by the objective indication that the defense had indeed waived their right to rely on the court's discovery order. That is the only hole one might have considered in the previous argument that we made in this regard. But we do not deserve to be sanctioned, Your Honor. We had a limited period of time to make a very strong decision, and I believe our decision was a correct one, though I did not happen to participate. I believe I would have made the same decision because it was clear the defense had waived any other kind of enforcement when they decided to, when Mr. Scheck decided to try and make a big deal of this in front of Mr. Fung.
But waiver, to be a valid waiver, it requires full knowledge, doesn't it? And if they don't know that you've got it, how is that a knowledgeable or complete waiver?
They waived it because they waived inquiry. They waived inquiry. Now,
You're not entitled to rely upon your representation, and when I say generically your representation, I mean the prosecution, these are the documents, here they are. They can't rely upon your integrity or the prosecution's integrity that this is in fact a complete set of documents.
I don't think it was reasonable reliance.
Okay.
Yeah, Your Honor,
The
We
judge
need to wrap this up.
did point something out when this was happening that not one person from the prosecution has repeated back to him hard. He gave them an answer to help them climb out of this mess, and nobody has said it. Page 4 was a blank form with nothing on it. The copy that Fung had in his hand was a blank form with nothing on it. Nobody wrote on it. There was no information on that form in any way. The only difference between the blank form and the photocopy were 2 staple holes up in the corner. So literally nothing was changed or different.
they were entitled to seek to ascertain the truth, and they were entitled to the court's order, which the court was convinced it should give with regard to these documents. Considering I'm told we're up to 28,000 items of evidence, pages, and including altogether 28,000 items of evidence we have turned over to the defense.
That's a
They
good
have not
point.
hesitated to bring it to our attention previously when they've been aware, when it's become apparent to them that
That's
some
not a
mix-up
good point.
in some manner, they didn't get something that they wanted. And in this instance, when I don't know if it's Mr.
Terry
Hodgman or Mr.
did
Yeltsin or
that.
whomever discovered that we had inadvertently
Yay.
failed to turn over one particular original. That showed our good faith. If we knew, we would have done it. But no, I don't think in this situation, they don't come to this with clean hands, Your Honor. The equities is not in favor of the defense on this, not when we've had a past history of dealing with them repeatedly throughout the 11 months that we've been in this, 10 months, 11 months we've been in this case now. Repeatedly dealt with them on an informal basis. So if there's anything they didn't want, Mr. Hodgman has sat, I know, Your Honor, in chambers with the lawyers with regard to all this DNA stuff on countless occasions, trying to all comply with all of this informally and trying not to have to burden the court with too many discovery matters. The court has heard a lot of them, but there's been a lot done informally that we've not had to burden the court with. So to make an issue, make a mountain out of something that doesn't even come to a molehill, it's not even a grain of sand or a little tiny piece of dirt in this instance, is really unfair. And it's unfair to the prosecution, Your Honor.
All right, I think we've used our allotted time.
I'm sorry, can I just have one moment, Your Honor?
One moment.
Your Honor, I just do want to make the final point, and we do have it in our papers that the prosecution has been sanctioned numerous times in this case. And, the court made those determinations, but we have been sanctioned numerous times. We've just this morning heard of, through an offer of proof from Mr. Blazier with regard to what an expert has told them on something that we've had no discovery of. So we're still in this. And I also want to draw the court's attention briefly to the beta tapes. There was a day when Mr. Scheck said, we have no beta tapes, period.
Well,
We, the
counsel, that's
defense.
really apples and oranges. I don't evaluate all of these things as a running continuum necessarily. This is a specific order and a specific incident. So let's confine our comment to that. And counsel, you've exceeded the amount of time. All right.
All right, thank you.
All right, thank you, counsel. Mr. Scheck, any response that you find necessary?
Just briefly to the substance, and I won't take the bait of, I don't know why they always have to say something about my honesty every time this issue comes up.
Because you're a liar. Liar, 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 liar.
In any event, my concern is that when they came back and said, this L1632, we found in Mr. Fung's notebook, middle of cross, when even an issue was made, where's the original of that document? It's undated. They were on notice that they might not have produced originals from his notebook. And it appears from the testimony very clear that the process of fielding the originals, and to the extent we can even be sure these are still originals, comes from SID, from Mr. Fung, Mr. Matheson, through the prosecutors. Then there were all these questions on redirect examination trying to bolster and vouch for the way in which Mr. Fung and Mr. Fung and SID, how honest they are, how the documents themselves can be trusted, that they don't throw anything away, that they don't tamper with them in any way. And at one point, I think is worth noting, they keep on saying it's a blank page, and therefore it had no evidentiary significance. That was the point, that it was a blank page. That, frankly, is still the point. And we still have in those documents this whole line of proof. I know they don't like it, that there was some manipulation of Mr. Simpson's blood vial, that it was mislabeled. It was item 18, indicating it was received after the sneakers. This is still a contested issue in this trial as to the amount of blood in the vial. It's going to be a contested issue all the way to the end. So I think that this is a significant point as to the credibility of the witness. And I don't think there's any issue that they not only intentionally did not comply with the order, they didn't give us a chance to deal with it as an advocate can. They tried to attack not only our credibility of advocates, but most importantly, they tried to vouch for the credibility of the way they handled discovery and credibility of the witness on this issue of of real importance to the case. So those are the elements that it seems to me were that I think
How?
they
Excuse me,
have
stop. How? Please tell me one way that is important to the case. Just give me one reason why them giving you a photocopy of a blank form instead of the blank form is important to this case. There's no reason.
founded since this issue first arose, and that the court really should take care of in the order. It's clear they misled us. They were on notice of the source of their mistake. They didn't take any action to change that, if it indeed is the original. They exploited it intentionally. They then, on redirect examination, vouched for the credibility of the witness. So I think that we're entitled to the elements that I think we're missing from the court's charge about their violation of law. In the first instance, their intentional misconduct in the second instance, they're misleading us, whether it's by mistake at first and negligence certainly at the least second. And finally, that their efforts, their intentional misconduct was the way they conducted the redirect, try to vouch. I think we're entitled to that element of the charge, that the jury may consider the failure and the intentional failure to bring this to the defense's attention on the credibility of the witness, because it was it did reflect on the witness, and it was something that they were vouching for in terms of the proper handling of the documents and discovery. So I think we're entitled to all those elements. And again, I urge the court, they delayed this by every means possible. So now we're really at a point that, again, if the court is not going to give a strong charge on this, it's not worth doing. It's more of a problem for us than it's worth.
All right. Thank you, counsel. All right. I'm going to review some of the commentary in the transcript before I issue the ruling on this. And at that point in time, after I issue a ruling, I'll give the both parties an opportunity to look at that before I go forward. All right. Also, I'd like counsel to consult in the meantime about what piqued my interest earlier today, the comment about by Mr. Blazier about in the offer of proof regarding EDTA testing, whether or not there's a discovery issue there. That should be handled informally first. If I need to take it up, we'll do that on Monday. All right.
Mr. Blazier mentioned to me he had a plane. He was hoping to get out by noon. I don't know if he's still here.
No, I know. But I understand, since we have 5 other able lawyers here, that somebody here knows about this. All right, Mr. Neufeld.
When would you like to take up the issue of the DNA boards for Dr. Cotton, who I believe will be beginning to testify sometime on Monday?
All right, have we displayed those?
We had viewing by the defense of the various boards, and I believe Mr. Neufeld indicated there may be some objections to some of them. They're upstairs and somewhat voluminous. At least they're heavy.
All right, then why don't we do this 8 o'clock Monday?
They have to change the boards. I don't know if that's, we can indicate, I don't know.
Well, I mean, are counsel available this afternoon? Mr. Clark?
Did the court have a particular time in mind?
Well, I'd like to get some lunch one of these days. You want to come back, say, at 1:30, 2 o'clock? Informally, and we'll just take our coats off and look at these things and see what we got?
That's fine.
All right, 2 o'clock.
One of the printouts that was not previously marked of a blood vial, and I don't know whether we need to separately mark our little red.
Let's do that Monday.
Okay, so can we take them, or should we leave them in the court's custody?
No, leave it in the court's custody.
Was that to be 1:30 or 2, Your Honor? I'm sorry.
2 o'clock, and it'll be informal. We won't have a court question. Present before the court with counsel, Mr. Shapiro, Mr. Cochran, Mr. Blazier, Mr. Scheck, and Mr. Neufeld, people represented by Mr. Darden and Mr. Goldberg. The jury is not present. Counsel, anything we need to take up before we proceed with our next witness. Mr. Goldberg, my recollection is that you had some exhibits to mark.
Yes, I wanted to mark the printout of the picture of the tube. I think it's 231, Your Honor. And also the little disposable plastic pipette. Maybe we can mark this as part of the 163 series, the bag of items.
No, I think because it will appear there out of logical order, I would suggest that we give that a new and separate number.
So you want this to be 232?
Yes. 232, Mrs. Robertson.
Thank you.
Your Honor, the next witness is the tow truck driver. He's being transported here by DA investigators. They have radioed us and said that they should be here around 10 minutes after 9. I informed the clerk as soon as I found out. Apparently, he was here this morning. He had left the document, the impound documents, and they'd taken him back to Santa Monica to pick up the documents. And he's on his way back now.
All right. And who is this next witness?
That'll be Mr. Durow. Dr. Cotton.
Robin Cotton. Certainly.
Your Honor, I have arranged with Mr. Hodgman to have Dr. Michael Bodden and Dr. Barbara Wolf here today. They are presently, actually, Dr. Bodden is testifying next door for the prosecution in another case. And the purpose of their visit for us is to get microscopic slides of tissue from the autopsy of both decedents. This has been agreed to by both sides. The only issue that has come up now is the cost of those slides. We are informed that the standard procedure is for the county coroner to do those slides, and they are provided at no cost to the defense. In this case, the coroner's office did not do any slides, and they are now allowing us to do the slides, but at a cost of $85 per slide. We understand that the true cost for such slides in laboratories is $4 to $5. I tried to reach Mr. Hodgman on Friday, and he had a family emergency and was unable to return my call, although we did get word back from someone else in the district attorney's office. We need the court's guidance. Those slides are going to be done this morning, but we, as I understand, there are going to be numerous slides necessary, and I don't know the exact amount, but we would like to see if the court can give us some assistance in providing these at a reasonable cost and not at an inflated cost that is artificially set by the coroner.
Mr. Darden, do you know anything about this?
No, I don't. And Mr. Hodgman is upstairs in his office. If he's listening, perhaps he can come down and speak to Mr. Shapiro while we wait for Mr. Durow, and they can settle the matter if at all possible.
That'll be acceptable.
All right. Anything else we can take up before we start with the tow truck driver?
I filed a letter with the court and counsel this morning. I followed up on your suggestion based on Mr. Blazer's hypothetical and good faith basis for his questions about EDTA on prosecution evidence. As you recall, Mr. Blazer alleged that their experts have reviewed our reports, which is all they could have done because they've never tested any of the samples from the gate or the sock for the presence of EDTA. And I requested Mr. Cochran orally, and now I've done it in writing. There are no such witnesses on the defense witness list who are qualified in the field of GCMS, which is the form of testing that would have to be done. So it appears that the defense has violated the court's discovery order by, at a minimum, based on Mr. Blazer's offer of proof, that their experts have reviewed our work and come to contrary conclusions. Our experts, the FBI, has determined that there is no EDTA on 117 or 13A1. So Mr. Blazer's offer of proof was that their experts have reviewed that material.
Well, Mr. Harmon, forgive me for interrupting you, but your request was for a hearing on this matter on Wednesday.
Right. We had time. I thought I'd bring it up that things are getting interesting, Your Honor.
How about if we do it Wednesday?
That'd be fine.
All right. Any other housekeeping matters while we're waiting, Mr. Goldberg?
Just briefly, on the magnetic strips that we used on the defense blood vial chart, I believe those probably should be marked as another exhibit as well.
However, my recollection is that Mr. Fairtlow took some type of digital photograph of that.
He apparently did, to preserve the way the chart once it was completed. Is it possible for us to mark both the magnetic strips and the photograph that was taken of the chart after it was finished?
I would say the photograph itself is what we ought to use rather than the strips themselves.
Well, unfortunately, the resolution on the photograph doesn't appear to be high enough to read all of the markings on it clearly.
All right, well, I would suggest then at the time that the court is in recess that that chart be put back together in that manner and that a still photograph by somebody from the district attorney's photo lab be substituted for the digital photograph. Rather than because the magnetic strips themselves without something to stick them on are useless as an exhibit.
And we can then mark the photographs separately, is what you're saying.
Yes,
Thank you.
seems to be a more reasonable way to do that.
Maybe mark this one now as one
233.
233. Can we make it 233A? And
Well, let's
then
make it 233, and then we'll, if the hearing no objection from the defense, we'll substitute a photograph with conventional photography when that becomes available.
Thank you.
Mayor, one quick item.
Yes.
We have a letter that we prepared for the court requesting sanctions against Mr. Goldberg for the series of improper questions that he asked on Thursday and Friday. We're asking for a curative instruction as well as sanctions, and we'd like to present that letter to the court now for the court's consideration. I believe you have it.
Yes, I do. I have not had the opportunity to read it since it was just handed to me. All right, we'll take that since it deals with EDTA as well. We'll take that up Wednesday afternoon. Mr. Scheck.
One more housekeeping matter. I've asked Mr. Harmon since Thursday to inform us of the status of the combination of samples from the Bronco that was being tested by DOJ, whether that RFLP analysis had started, as I indicated to the court. I was told as of Monday of last week it hadn't, and I think that creates an issue to be resolved.
Yes, we've discussed that informally previously.
When should we do this? And what's the court's pleasure?
Well, obviously, if that testing has not even begun yet, then there are no results to report, so there's nothing to be produced in court. So I don't see any tremendous urgency to do it this week.
Well,
and we have a plethora of other issues to deal with Wednesday.
I understand. My only concern is before the witness from the Department of Justice testifies about results from the Bronco, which are going to be affected by the tests that they proposed to do 7 weeks ago, that they did not begin after they obtained permission of the court to do so, which I would submit on its face is deliberate. That we have to have some resolution as to.
Well, what do you suggest timing-wise?
Well, first of all, Mr. Harmon hasn't informed us as to what the status of the testing is. I want to be careful in my representation since my information is a bit old, but my suggestion is that we resolve that issue before Mr. Sims testified from the Department of Justice, which could be at the end of this week or the beginning of next week.
Mr. Darden, do you have any information about that, or do you want to defer to Mr. Harmon?
I'd like to defer to Mr. Harmon. Your Honor.
I'm not sure what the question is, Judge.
The question is the status of the combination RFLP testing.
It's
at,
ongoing. And Dr. Blake has open door. The invisible but ubiquitous Blake is there more than I am. So I'm not sure. He's never been denied access to any information. I can tell you Mr. Sims is not doing that work because he's down here now. So nothing's going on right now. But I'd rather, if there's a specific legal issue involved in it, I'd be happy to respond to a legal issue. But in terms of where the testing is, Dr. Blake can call up there anytime and be precise. But it hasn't been completed, obviously.
All right, well, Mr. Harmon, when do you anticipate, after Dr. Cotton testifies, who do you anticipate will be after Dr. Cotton?
Mr. Sims. So he's here until, so wherever things were left when he left work on Friday, that's where they are.
All right, then Friday afternoon, 1:30, we'll take this up. Mrs. Robertson, would you note that? Remind me to cancel my dentist appointment. Again?
Come on, Judge. You
Mr.
know
Darden,
better.
Any word on the whereabouts of your witness?
No, Your Honor.
Well, could we perhaps start with Dr. Cotton?
Do you want to start with DNA and interrupt it with the tow truck driver?
No, I'd like to do something this morning.
Why don't we check? We've been on the record 12 minutes. We've been accusing misconduct twice. We're setting the record pace at this point, Your Honor.
Once every 6 minutes.
Yeah, one every 6 minutes. Besides, Miss Martinez's birthday was this. Where did she go? There she is. Her birthday was this weekend.
She knew when to get out of Dodge. Yeah. Ah, the ubiquitous Mr. Hodgman.
And his sidekick, Mr. Yokelson.
Good morning, sir. There was some dispute that Mr. Shapiro raised concerning cost of production of autopsy slides from the coroner's office. Do you have any information about that? Not that I want to get involved in refereeing a dispute.
Yes, very well.
I'm not so sure it can be characterized as a dispute. It's simply the policy and protocol of the coroner's office, of which I informed Mr. Shapiro by letter last week. And I received a phone message Friday indicating Mr. Shapiro wanted to try and work something out in that regard. But I don't control that department, and that's between the coroner's office and the defense. I understand Doctors Bodden and Wolf are over there today. I had spoken to Dr. Wolf Friday morning, just to make sure she had the proper information with regard to the arrangements as well as the cost procedures, and she did not raise any objection at that time. Mr. Shapiro's call did come in after that. So it's something over which I really have no control, Your Honor.
All right, well, Mr. Shapiro's raised the issue. Mr. Shapiro, I think the burden is on your shoulders at this point to indicate that those costs are somehow out of the ordinary or unlike those that are assessed to other individuals seeking this information.
Your Honor, I can just relate what has been related to me by our experts, and that is that in the normal course, these are provided for at no cost whatsoever, and that the medical costs and laboratory costs that are involved are between $4 and $5 a slide. In addition, since Mr. Hodgman is here, I don't even, in his letter, they indicated that the approximate cost, and I don't have the figures in front of me, of Dr. Lakshmanan and Dr. Golden to watch our experts do this is approximately $500 an hour for us, to have them watch us do what they should have done. And we just think this is a violation of due process. We have no choice but to go ahead with it because the doctors are here. But we would ask the court to intervene and to conduct a hearing regarding the real fair cost of this, and that we should not be gouged because it's being done by the defense and not by the prosecution.
All right, about the only thing I can suggest, Mr. Shapiro, is if you want to file a motion to that effect, you're welcome to do so. It would be my inclination to, since it would involve a coroner's policy, which would apply not only to this case, but other cases, is then ask the supervising judge, Judge Basque, to set the matter for a hearing, since it would be a system-wide impact, since some other judge should probably hear that issue and not take our time with that.
Yes, Your Honor, and it would indeed be a system-wide impact because I am informed that this policy applies across the board for all defendants, that there is nothing unusual that's being done in this case, that there's no denial of due process. This is simply the normal protocol and usual procedure of the coroner's office. So nothing special is being done for the defendant in this case.
Okay.
All right. Witness will be here in a minute.
Well, shall I put the jury in the box and we can all wait?
That's no fun. Yeah. Wait until the defense case, Your Honor. It's on the S level. There's only one elevator operating from the S level.
Your Honor, there is one additional thing that I just want to add for the record, so the record is clear. In addition, they want a copy of our slides that we are doing, and they want to charge us $85 per slide that we are doing to turn over to them because they didn't do it.
Sounds like a good business to me. All right. We'll, if you want to file a formal motion, we'll look into it.
I will.
All right.
You can go in the chambers and read, some of the sanction motions.
Well, the problem is if I leave, then the audience has to be cleared. Then we have to go through all of that rigmarole each and every time. So I just assume stay here upon your representation of that person will be here in 2 or 3 minutes.
Well, okay.
Thought of an interesting sidebar.
All right. Well, perhaps you could ask Mr. Delavine for some advice. Never mind.
I thought maybe he was here.
He could be.
If I can have 60 seconds outside with defense counsel. Quiet, please.
Ms. Clark, what's your time estimate for the next witness?
sorry?
What is your time estimate for the next witness?
People's time estimate or the estimate for cross?
Your time estimate.
No, 15 minutes, is that?
Right.
Very brief, so that means, that's direct, so cross, figure it'd be about 2 hours.
Depends on what the issues are here. All right. Which of the tow truck drivers is this? Which of the tow
The
truck?
first,
First
the
truck.
first one, who towed to Ruben's, the creation.
Okay.
All right, I got more coffee, so I'm ready for more of this stupid, stupid stuff. I don't know what I missed. Apparently, I missed doctors. $500 an hour.
Step in with their witness, please.
Whoo! Whoo!
Mrs. Robertson.
Mrs. Robinson is the glue holding this whole court together. Good job, Mrs. Robinson.
All right, Mr. Darden, people ready? All right, Deputy McNair, let's have the jurors, please.
We found the tow truck driver. Is that what we're doing right now? The tow truck driver? My daughter's leaving.
Let the record reflect that we've now been rejoined by all the members of our jury panel. Good morning, ladies and gentlemen. All right, Mr. Darden, you may call the people's next witness.
Thank you, Your Honor. Good morning. The people call Mr. Duro, Your Honor.
All right, Mr. Duro, would you come over here to the witness stand, please? Raise your right hand and face the clerk, please.
Raise your right hand, please. You do solemnly swear that the testimony you may give in the cause nothing before this court will be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Please have a seat in the witness stand and state and spell your first and last names for the record.
Bernie Duro,
Please spell your first and last names.
BERNIE DOUROUX.
All right, Mr. Darden.
Thank you, Your Honor. Mr. Duro, who are you working for on June 13, 1994?
Ruban Motors.
Ruban Motors?
Yes.
Okay, could you pull the microphone a little closer here and speak into it?
Okay, Ruban Motors.
Sounded the same for some reason.
This is better.
Okay.
Ruban Motors.
Okay. And Ruban Motors is a towing,
It's
automobile
police
towing
impound.
company?
Yes.
And what do you do for Ruban Motors?
Impound vehicles at LAPD. Should request have impounded or private towing.
Mrs. Robertson, correct it.
Okay, thank you. On the afternoon of June 13, at around 3:06 p.m., did you receive a radio call from your dispatcher?
Yes, we did.
And after receiving that radio call, did you go somewhere?
Yes, I did.
Where'd you go?
360 Rockingham.
Okay, why did you go to 360 Rockingham?
We were requested by LAPD to pick up a vehicle.
And what time did you arrive at 360 North Rockingham?
Approximately 3:30.
And did you speak to a police officer at that location?
I spoke to a couple of them, yes.
Okay. And were you given any instructions?
Yes, I did. Yes, I was.
What instructions were you given by the officers?
Not to touch the vehicle, not to open it, and to take it downtown.
Okay. And were you directed toward a certain vehicle or to a certain vehicle?
Yes, I was.
And what vehicle is that?
Ford Bronco.
The Ford Bronco that's been on?
Yes.
Okay. Mr. Simpson's Ford Bronco?
Yes, sir.
And did you tow that Ford Bronco?
Yes, I did.
Did you touch it prior to hooking it up to your tow truck?
Not prior, but after I hooked it up, I did touch the front right tire just to make sure it was locked. The steering column was locked.
Now, during the time that you were at 360 North Rockingham, did you ever see any civilian touch the Ford Bronco?
No, I didn't.
And did you ever touch the doors or the?
No, sir.
Did you look inside the Ford Bronco?
I glanced inside, but didn't check to see anything.
You took a glance inside?
Just to make sure it wasn't full-time four-wheel drive. This little button sometimes tells you if it's four-wheel, full-time, but it was not.
Okay. Now, to take this glance inside the vehicle, did you open the door?
No, sir.
Did you ever touch the door handle?
No, sir.
What did you do to take this glance inside the Ford Bronco?
Just looked like that, and that was it. Took a quick peek.
Could you tell whether or not the Ford Bronco was locked?
Yes, it was locked because it had the buttons were down on the Bronco.
It was locked when you first saw it?
Yes, sir.
Did you unlock that vehicle?
No, sir.
And did you tow that vehicle?
Yes, sir, I did.
Where did you tow the Ford Bronco to?
To Parker Center, to Prince Shed, over here.
Okay. The Parker Center over here on Los Angeles
Yes,
Street?
sir.
To the Prince Shed?
Yes, sir.
Mr. Drill, would you allow Mr. Darden and the other lawyers to finish asking the question before you start to
Okay,
answer?
yes, sir.
So you just did it right now.
Okay.
The problem we have is that you speak very softly. The court reporter has to be able to write down everything that is said. If you start to speak when Mr. Darden is still speaking, she can't take down what's being said. All right? Thank you, sir. Just let everybody finish their questions. Mr. Darden.
What time, sir, did you leave Rockingham with the Bronco?
Approximately 3:40.
And what time did you arrive downtown at Parker Center? If you know.
It took me about an hour to get there. So probably about 4:40, 4:30. Like
And,
that.
and did you arrive at the Prince Shed?
All right, look at this, Bo. Okay, remember the Simpson? Nope, sorry. Nicole's whole family. They were each wearing little angels jewelry. For in memory of Nicole. And then Marsha Clark came into court that one day, and she had a little angel pin on, and the defense lost their shit. No, yeah, the defense lost their shit, saying that she was doing that to manipulate the jury or whatever. She had an angel pin on. Do you remember that? Yeah. So look at that. This is why. Does that man look like he normally wears a pretty little bow on his collar as a tow truck driver? Right, he's the tow truck driver, right? I was talking, so I might have missed it. I have never seen a tow truck driver wear jewelry on their work uniform shirt. Now it's silver. And I don't know if that's a big deal because all of Nicole's family were wearing gold, little gold angels. And I think that it's not an angel, it's a bow, because if he would have worn an angel, that would have been obvious. Now, I could be wrong. This man could just have a bow on his lapel because of any other reason. You know what I mean? Maybe he had a child that passed away, or, that the company cares about breast cancer and makes them all wear ribbons. But then it would be the other ribbon, wouldn't it? Anyway, could be any other reason, but I don't think so. I think he wore that on purpose. I think that is a fake angel because he couldn't wear an actual angel.
I was told to meet someone at the shed. There was nobody there. I had to go out to the front of Parker Center and request for a detective.
Okay, so you arrived at the Prince Shed and there was no one there.
Yes, sir.
And you say that you went inside Parker Center?
Yes, sir.
Okay. And why did you do that?
To let the officer know, or the desk person that was there, I had the Bronco, and I was supposed to meet a detective. And he called the detective. They came down. We went down to the Prince Shed.
Okay. And where was the Bronco during the time that you were speaking to the officers inside Parker Center?
In front of Parker Center.
Was there media there?
A few feet away.
Exactly.
Actually, about 15 yards away.
Okay.
Timu angel.
Seem to pay any attention to the Ford Bronco?
No, sir.
You see anybody approach the Ford Bronco
No,
at that
sir.
time?
No, sir.
Yo, 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 guys, it just hit me. Guys, we're back on the A team. We're done with the B team. Now, I know it's brief. I know it's so brief. As soon as this tow truck driver is done testifying, they're going to go back to science. But we're going to get the A team for what, a day? Maybe a whole day? I don't know. I'm so excited. Go ahead, Darden, let's go.
And after you spoke to the officers inside Parker Center, what did you do next?
Went back to the truck and stayed with the vehicle until the detective came out.
And at that point, did you return to the print shed
Yes, sir, we did.
along with the detective?
Yes, sir.
Now, the print shed, is this a locked facility?
Yes, it is.
And how do you know that?
We had opened it with a key. There's doors and it's all locked from the inside.
Okay. So you saw the detective open the locked doors?
Yes, sir, I did.
And what did you do after that?
Back to Bronco in, unhooked it. He took information down off the impound sheet, and that was it.
Did you see the detective open the Ford Bronco?
No, I didn't.
And when you left the Ford Bronco at the print shed, was it still locked?
Yes, sir, it was.
Now, at some point you left the print shed, correct?
Yes, sir.
And as you left the print shed, did you notice whether or not the detective locked the doors to the shed?
Yes, he did.
And how do you know that?
I saw him shut the doors behind me as I was leaving.
Your Honor, I have here a vehicle investigation impound report. May it be marked People's Next in order.
234.
And with the court's permission, after the witness completes his testimony, I'd like to substitute this document with the Xerox copy. Mr.
Hearing no objection.
Mr. Giroux, showing you what has been marked as People's 234. Is that a copy of the impound report?
Yes, sir, it is.
Now, is there a box on that report that indicates whether or not a vehicle was locked when it's recovered?
No, there isn't. It doesn't say. It just says keys, and it says no for keys. It doesn't indicate that it was locked. There's no box that shows it.
Now, let me direct your attention to the upper left-hand corner of the report. That portion entitled Stolen, Lost, Embezzled.
Yes.
Is there a box here that indicates whether or not the doors are locked?
Oh, yeah, right here.
Okay. Now, does that portion of the report apply only to stolen or stolen vehicles that are recovered? Or does that box apply to vehicles that are impounded, like the Ford Bronco in this case?
Well, according to this, just lost, stolen, and embezzled vehicles.
And have you been interviewed by the LAPD and DA investigators?
Yes, I have.
And have you also been interviewed by defense investigators?
Yes, I have.
Thank you.
Mr. Cochran?
Morning, Mr. DeRoe.
Morning.
Greetings, Mr. Mr. DeRoe, you and I just met about 5 minutes ago in the hall for the first time. Is that correct, sir?
Yes, sir, it is.
And with regard to your towing of this vehicle, as I understand it, this took place on or about June 13th of 1994 in the afternoon. Is that correct?
That's correct.
And can you tell the jury, ladies and gentlemen of the jury, what time you received the call in response to this, sir?
We received the call from the mic room, LAPD's mic room, at approximately 3:06.
And then you responded to that call and arrived at the location on Rockingham?
Yes, sir, around 3:31.
All right, about 3:31 in the afternoon?
Yes, sir.
And when you got to that location, was the media present at that time, sir?
Yes, they were.
And did you see a lot of media there?
Yes, there was.
While you were there at Rockingham, did you ever see a lady walk up or run up and touch this particular vehicle while you were there?
I know myself, no.
You never saw that personally?
No.
Did you become aware of that at some point?
I was told that when I was doing the interviews with the defense and with LAPD, they had mentioned it to me.
All right, so you learned about it afterwards.
Yes,
That's right. With regard to this particular vehicle, prior to the time that you started to prepare it for towing, did you have occasion to look at that vehicle, the exterior of the vehicle at all?
No, I didn't. Just after I hooked it up, just to make sure it was nothing, it wasn't for full-time four-wheel drive.
All right. You described for us that you touched, I guess, the front wheel part of the vehicle. Is that correct?
Yes, sir, the front right tire.
Did you have occasion to look at any of the doors of that vehicle at all?
No, I didn't.
And you didn't notice anything on the exterior of that vehicle that you can recall presently. Is that correct?
No, sir.
Did you have occasion to look at the driver's side door down by the sill, down at the bottom of that particular vehicle? at
No,
all?
sir.
Never looked at that?
No, sir.
Did you see what appeared to be any coffee cup stains on the hood of that vehicle?
No, sir.
You didn't see that?
No.
So I understand this was a fairly routine tow for you at that time. Is that correct?
Yes, sir, it was.
The only difference from this scene, from other scenes you've been to, was the fact there were a lot of media present. Is that correct?
That was it, yes.
You were working by yourself that day, sir?
Well, there was 3 other drivers that day, but I was the one who got dispatched the call.
All right. When you say 3 other drivers, the 3 other drivers who responded to the call?
No, just on the shift.
Working for Rubens that day?
Yes.
But you responded to the call, and when you got there to Rockingham at about 3:30 in the afternoon, you were the only driver there. Is that correct?
That's correct.
All right. You talked to a police officer once you got to the Rockingham location, did you?
Yes, I did.
And do you know the name of that police officer?
I can't remember his name, no.
Was this police officer in civilian clothes, or was he in uniform?
He was in civilian. The one who instructed me where to take the Bronco was
He was in what?
in civilian clothes.
All right. You don't know his name?
No, sir.
All right. So at any rate, you then proceeded, as I understand your testimony, to hook this vehicle up and then to transport it downtown. Is that correct?
That's correct.
And it was your understanding that you were going to meet a detective somewhere near in or about the print shed.
That's correct.
Is that correct?
Yes, sir.
And then you described for us that it took you perhaps an hour or more to drive easterly downtown to Parker Center to the print shed. Is that correct?
That's correct.
Where is the print shed located, sir, downtown here in LA?
Directly behind Parker Center on St. Pedro Street.
All right. And you went to that location, and did you see any detective when you first went there?
No, I didn't.
All right. So how long did you wait at that location?
Approximately 10 minutes, 10, 15 minutes.
All right. And what time was that by now?
I would say about 3:30, 3:40, something around that time.
Let's see. No,
No, about 4:30. 1 second.
So about-
4:40, around that time, about an hour after I left Rockingham.
So 4:30, 4:40.
Yes, sir.
All right. Did you talk to anybody at the print shed when you first got there?
There was nobody there.
All right. Nobody was like locked.
Yes.
All right, sir. So then you waited about 10 minutes, and then thereafter, as I understand your testimony, you drove around to Parker Center. Is that correct?
That's correct. You're from the Parker Center.
And you were by yourself at this point, and so when you went in to try to locate the detective, you left the vehicle on the street. Is that correct?
That's correct.
And so how long were you away from that vehicle when you left it?
Approximately 3 minutes. Just go inside.
All right. Now, what street did you park the vehicle on, sir?
Los Angeles.
On Los Angeles Street?
Yes, sir. Right.
And is that in front of the Parker Center?
That's correct.
Out on the street, so you would be heading northbound on Los Angeles?
I thought it was eastbound.
Well, you're on Los Angeles Street, right?
Yeah, it was directly right in front of Parker Center, in front of the
Okay.
doors. So
All right.
I thought it was eastbound. Anybody?
All right. You headed toward Union Station, would you?
That's correct.
Toward Olvera Street?
Yes.
So let's call that northbound.
Okay.
All right. And you parked the vehicle there in your vehicle. Is that correct?
That's correct.
And you left it, and then you went inside Parker Center, and the front doors of Parker Center.
Yes, sir.
When you left the vehicle to go inside, the media was outside also?
Yes, they were.
Can you approximate for the court and jury how many members of the media were there, sir?
Yeah, it was a group. I couldn't. Maybe 10, 15 more.
A group
Could
like
be more.
a pack of media?
Yeah, they're all hanging out on the
Like a
lawn.
pack? How about a swarm of media, Your Honor? So how many
I would
media?
say probably about 10, maybe more.
So about 10 different
Yes.
cameras and that sort of thing.
Exactly.
And how far away were they from you at the time that you went inside, when you left the vehicle to go inside Parker Center?
It's about 15 yards.
15 yards away?
Yes,
And then you then left the vehicle and went inside, is that correct?
that's correct.
And you went inside to try to find a detective, is that correct?
I went inside and I asked the desk sergeant there, the person in charge. I had a Bronco with me from 360 Rockingham. He called upstairs and he told me the detective was on his way down.
All right. And then, and that's kind of at the front desk. When you walk inside Parker Center, it's at the front desk inside there. is
That's
that
correct.
All right. And during this time while you're inside, there was nobody outside with a Bronco at that point, is that correct?
That's correct.
All right. So your best recollection is you stayed inside for how long? Did you wait to strike that? Did you wait for the detective inside?
No, sir, I didn't.
All right. After you talked with this desk sergeant, you were told a detective would be coming down. Did you go back outside then?
That's correct. I did.
And then you walked back outside to the vehicle?
Yes, sir.
All right. And I presume it was still parked at the same place, is that right?
Yes, it was.
And did you wait outside with the vehicle at that point?
Yes, I did.
When you went back outside to wait for the detective, how long did you wait before the detective came out?
About 3 minutes.
All right. And
Less than 5 minutes.
less than 5 minutes?
Yes.
During that period of time, Mr. Duro, did you have occasion to look at the exterior of the Bronco at all at that point?
No, sir.
So up until the time that you left that particular vehicle on June 13th, 1994, you never had occasion to visually inspect the exterior of that vehicle. Is that a fair statement?
Yeah, never just took a quick glance to see there was no damages, and that was it.
Did you have to log on any particular form whether or not there was damages at any place on that
It's
particular?
usually marked on this. When we could look over the vehicle, make sure there's no damages. If they are, we mark them down on the impound sheet.
And that's called some kind of an inventory on this sheet that you have before you?
Yes.
And in completing that particular inventory form, for instance, the form is called inventory. It's near the middle of the particular form. Is that correct? Inventory?
Well, however it says remarks, that's where we put all the damages down.
Okay. And you have a Y column, I presume that's for yes, and an N column for no. Is that correct?
That's correct.
And did you fill this form out?
No, sir, that was already filled out by
All right.
LAPD.
It was filled out by LAPD.
Yes, sir.
When you got the form?
Yes, sir.
Where'd you get that form?
I'm from LAPD on Rockingham.
When you first arrived there?
Yes, sir.
All right. And so that we're clear, may I approach you?
You may.
This form, for the record, Your Honor, we are referring to People's 234 for identification. If we can look at 234, this particular form, where there's an indication of tow information and inventory, these kind of X marks here under Y and N.
Yes, sir.
These were filled out by someone else, is that correct?
That's correct.
Did you fill out any portion of this form at all?
Just the part here for my signature is the tow fee and the storage fee.
All right, you fill out just the part where it indicates garage employee, complete this section, and where it says garage employee signature, that's your section. And your name is Bernie Duro?
Duro. Yes, sir.
All right. Anything else filled out by you on this particular form?
No, that's it.
All right. And so with regard to the inventorying the vehicle, you just quickly looked at. Is that correct?
That's correct. Just the exterior to make sure there was no damages, there were none.
Now, you mentioned also, sir, that at some point you had occasion to glance inside the vehicle. Is that correct?
Yes, sir. Just through the window, just to look, see if it was for a lot of vehicles. Sometimes are four-wheel drives, so we just have to make sure they're not engaged.
All right.
But I didn't see anything when I glanced, so I didn't bother looking.
And where were you when you glanced inside the vehicle?
On the right-hand side, on the passenger side.
All right, and more specifically, what location were you at?
On the front.
No, where were you? Were Rockingham?
Oh,
or
yes,
Park
I'm
Center?
sorry. Yeah,
Okay.
Rockingham.
So as I understand it, then you looked inside the vehicle while you're still at 360 Rockingham.
Yeah, we just glanced in. I looked.
And you did this from the passenger side of the vehicle, is that correct?
That's correct.
And you don't recall seeing anything that you noted inside that particular vehicle, is that correct?
That's correct.
All right. This would have been shortly after you arrived, about 3:30 in the afternoon?
Yes, sir.
That you looked inside? All right. Now, when you went back outside after talking to the desk sergeant, you waited for a period of time of perhaps less than 5 minutes, and the detective came out. Is that correct?
That's correct.
Do you know the name of that detective, sir?
No, I don't remember.
And you talked briefly with that detective, you had a conversation with that person?
Yeah, weather.
Talk about the
Just,
weather?
just weather and how, because it was nice one day. But
Okay.
other than that, no conversation.
June 13th was a warm day?
It was.
All right. And so after you had this conversation with the detective, did you then take the vehicle back over to the print shed?
Yes, we took it over there. He got in the truck and we went to.
So this
print
detective
shed.
rode with you?
Yes, sir.
All right. You went back to the print shed, and this time you gained entrance inside the print shed. Is that correct?
That's correct.
And you, I presume, took the vehicle inside and parked it in some location. Is that correct?
That's correct. I backed it in and dropped the vehicle.
And about what time was it at that time, sir?
Yeah, maybe 4:45, maybe almost 5. By that time, it's
somewhere around 5 o'clock in the afternoon.
I believe it was before 5.
All right. And you then left the vehicle. Is that correct?
That's correct.
While you were there, did you ever see any person get inside that vehicle at all?
No, sir.
And did you ever get inside it?
No, sir.
By the way, do you carry in the course of your work as a tow truck driver? Do you have one of these things called a Slim Jim?
Yes, I do.
And that is a kind of an instrument that works to open vehicles. Is that correct?
That's correct.
And with regard to that Slim Jim, you could open that vehicle real quickly, couldn't you?
Yes, I could.
I mean, you're an experienced,
Yes.
experienced tow truck driver. How long would it take you to use your Slim Jim to open a vehicle like that, Bronco? Oh, how long would it take?
A couple minutes. If I had to open it.
I guess if you want to open a couple of minutes.
Yeah.
Did you see whether or
No,
not
no,
the
no, no,
detective?
no, no. Excuse me, sir. We have an expert here that can answer that question better. How long does it take to open with a Slim Jim? If only we had an expert in chat that can just type 15 minutes, 5 minutes, 30 seconds.
Who rode back over with you to Parker Center? Did you see whether or not he had a Slim Jim with him?
I didn't notice one. No.
And did you ever see the detective open the vehicle while you were there?
No, sir.
You then left the vehicle, and that ended your involvement with this vehicle on that day. Is that correct?
That's correct.
Did you strike that? With regard to the form that's before you again, People's 234 for identification, you were asked by Mr. Darden whether or not there was any indication on the form of whether or not this vehicle was locked, and you indicated there's no indication one way or the other. Is that correct?
That's correct. I really didn't even notice the part up there.
So look at it now for me, will you?
Yes.
In an area called stolen, lost, or embezzled, there's an indication in the right part of that block that whether or not the ignition was locked, right?
That's correct.
There's nothing checked, right?
Nothing.
There's an indication whether the doors are locked. There's nothing indicated, right?
Nothing.
All right. And you had not noticed that before you brought,
Yeah.
brought the form with you today. Is that right?
That's correct.
You then left the print shed, and it was about 5 o'clock or so that afternoon?
About 5, yes, sir.
And what time did you check out that day from your terminate your employment that day, if you recall?
At 7 o'clock.
And did you pick up any other vehicles on that day that you recall?
Before it was.
Oh, well. I knew you. Response.
Before, a few cars before.
No, afterwards.
No.
All right. Maybe put you just a second here.
Do we have to?
Yeah, just to be very brief. I won't pay.
All right, Mr. Cochran.
You done?
Did you write any other notes with regard to any of your observations on that from that particular date, other than your signature on People's 234 for identification?
No, sir. That's it.
Pretty much it.
Yes, sir.
And with regard to your observations or lack thereof of things either outside the Bronco or inside the Bronco that you saw, did you write those down anywhere at all?
No, sir.
And you never saw anything inside in the interior of that vehicle, is that correct?
No, sir.
Never saw any blood inside that vehicle?
No, sir.
Never saw any blood on the outside of that vehicle?
No, sir.
Did you see anything in the rear of the vehicle at all?
No, sir.
Go. Thank you for your comment, Mr. Rowe.
Okay.
Thank you.
Mr. Darden, any redirect?
Mr. Durrell, you didn't notice any unusual stains on the steering wheel of the Bronco?
No, sir.
You see any unusual stains on the console of the Bronco?
No, sir.
How about the interior driver's door panel? You see any unusual stains there?
No, sir.
Thank you, sir.
Mr. Cochran?
Nothing further, Your Honor. Thank you very
All right,
much.
Mr. Giroux, thank you very much, sir. Your excuse is witness. Thank you for coming in. And if you'll give that document, please, to Mr. Darden. Mr. Darden, do you have your people's next witness available?
I think so. Just have one moment.
Yes.
I hope you guys enjoyed your time with the A team today. We are going back to the B team, but remember, we will get past the B team
All right,
again
give me 2 seconds
eventually
here.
and back to the A team again. We just need time. She is going to be on the stand for a long time. Let me show you. Oh, geez. All right, this is May
Sir, can
8th,
we do that someplace else? Great. All right, Mr. Clark, you may call the people's next witness.
Yes, thank
May
you, Your Honor. Dr.
10th,
Cotton, please.
All right, Dr. Cotton.
May 12th, May 15th. And after her, I don't know who the next person is. At least till May 15th, minimum.
My first name is spelled Robin, and the last name is Cotton.
All right, Dr. Cotton, why don't you just lean back, pull the microphone close to you, please?
With permission, may I reintroduce myself to the jury?
You may.
All right, thank you, ladies and gentlemen. My name is George Clark. Actually has an E on the end, so I'm no relation to Ms. Clark. Thank you, Your Honor, and good morning, ladies and gentlemen.
I didn't need that disclaimer. My
Dr. Cotton, who are you employed by?
I'm employed by Cellmark Diagnostics in Germantown, Maryland.
What is Cellmark Diagnostics?
We are a private company and we do DNA testing for paternity and for criminal cases.
As far as your formal education, do you have any higher level or upper level degrees?
Yes, I do.
Could you describe that, please?
I have a master's degree with a major in biology, and I have a PhD with a major in biochemistry and molecular biology.
When you say biochemistry, could you explain what that is?
It's just the methods and information that's gathered by those methods in an attempt to understand basically all cellular processes.
When you say cellular processes, can you tell us a little bit about that?
Well, except for viruses, all organisms are made up of cells. Bacteria is a cell, a yeast is a cell, and we are made up of many, many cells, and biochemistry and molecular biology are the tools that a biologist uses to try to understand how cells function and how they are able to do the things that they do.
Could you also pull the microphone perhaps just a little bit closer to you?
How's that?
That's fine, thanks. You also described that your higher level degree was also in molecular biology, is that right?
Yes.
Could you describe what that is, please?
Molecular biology is sort of a generic term and really refers to a set of tools that biologists may use to help them understand any number of things. Maybe a biologist would use the tools of molecular biology to find out where a particular gene or genetic characteristic was, or they might use the tools to understand how a particular gene or genetic characteristic causes a cell to do a particular thing. And that can be applied to research in animals and research in humans, research in bacteria. It's really the set of tools that is used in understanding cellular processes.
To what extent did your formal education deal with DNA itself?
Most of my graduate, well, actually, the work that I did for my master's degree didn't have anything to do with DNA. The work that I did for my PhD and research that I've done since then has all had something to do with understanding DNA.
All right, I'd like to return to your qualifications later. But first, what is DNA, Dr. Cotton?
DNA is that part of the chromosomes that carries the information that programs an organism from the point of conception, that is, from the point when an egg and a sperm come together. The DNA in the egg and the DNA in the sperm now makes up the total DNA for that organism. And the information in that DNA programs the development of that organism all the way through childhood, if it was a human, adulthood, and on through aging until that human being isn't alive anymore.
What is DNA itself? How would you describe it?
DNA is correctly described as a polymer. That is, it's a long series of components that are all attached together. And it's basically our cellular alphabet.
When you use the term polymer, could you spell that, please?
Polymer.
What role does DNA play in terms of inheritance from parents to children?
When the egg and the sperm come together to start a new animal or a new human being, the egg contains half of the DNA from that human being, for that new person. We'll talk about people, so I don't have to keep referring back and forth, people, animals. It's generic, but anyway, the egg contains half of that DNA for that new person. The sperm contains the other half. So we inherit one half of our DNA from our mother, and we inherit the other half of our DNA from our father.
As far as DNA's role in the body, and you've described the fact that it provides for the structure, for instance, of human beings, is that right?
Yes.
And when you say structure, or if I've used the term structure, what role does DNA have in creating our bodies?
You could take an entire series of college courses that would answer that question. So let me see if I can make a simple answer for you. All of the information that predicts our structure, our height, our build, our skin color, our organs. You have a liver. That information on how that liver is going to be formed as the organism develops is contained in the DNA. And the DNA does that by containing the information that's eventually translated into proteins. And those proteins do the major part of the work in the cell. And so basically the DNA contains all information to make a specific organism.
Sometimes the term genetic blueprint has been attached to DNA.
And it's a good description.
In what way?
Well, if you think of a blueprint as all, I don't know much about how you build a building, but if we make the assumption that a blueprint contains all the information for how to build your house, the DNA, the analogy is the DNA contains all the information on how to build you.
Where is DNA actually found in our bodies?
It's found in the nucleus of each cell.
Okay, do we have, and in fact, have you and I discussed the fact that we will be drawing some charts for this jury?
Yes.
And will we, in fact, be talking to your knowledge about some of these very same items that you've just described?
Yes.
Is there a term called chromosomes?
Yes.
What is that?
The chromosomes are really the DNA molecules packaged up in what's a more manageable form for the cell. There are 46 chromosomes, and you get 23 of those from your mother. You get the other 23 from your father. And the chromosome is literally the DNA molecule packaged up by some proteins. So we'll sort of disregard those proteins. We don't really care about those for purposes of this discussion. But there would be, since there are 46 chromosomes, there are really 46 molecules of DNA in each nucleus of each cell of a human being.
Would it help to illustrate that point about chromosomes and DNA for you to draw a chart for the jury?
Probably.
All right. Your Honor, then with the court's permission, may the witness utilize the tripod that Mr. Fairtlow has.
Yes.
And draw on a...
Could we possibly shoot this over on this side over here?
My only concern is that some of the jurors will be at some distance.
Well, the problem is I need the defense counsel needs to be able to see it as well. So what we'll do is after we complete the drawing, we'll exhibit it to the full jury panel.
All right, very well. Your Honor, perhaps this, what will be, I believe, a drawing by the witness be marked as a people's next in order.
235. All right, first drawing by Dr. Cotton will be 235. Mr. Chairman, is that about as high as that goes? All right. That back so we're not cutting off chair number one.
I'm sorry.
I'll just ask Mr. Farrell to move that back slightly so we're not cutting off chair number one here.
I was going to suggest if we could use the other tripod for the drawings, it'll get it higher, I think.
I don't know that,
Perhaps.
I don't know that it's attachable to that tripod, is it?
All right.
Well, let's make do with what we have here, and then we'll exhibit it to the jurors.
All right, Dr. Cotton, then with the court's permission, could you use this chart that's now been marked or will be shortly marked, People's Exhibit 235, to describe for the jury this concept of DNA and chromosomes?
Sorry, Your Honor. It has to turn a little bit so the defense can see it.
Well, counsel, who's going to be handling this witness on cross-examination?
I will.
All right, Mr. Neufeld, why don't you sit over next to Mr. Goldberg there?
Close to Mr. Simpson is not able to see it.
I understand that, counsel, but it's going to be exhibited for everybody. We have to make do with the angles we have.
And is there a color, Dr. Cotton? Do you have a pen in your hand? All right, very good. Then if you could please, for the jury, describe, again, DNA and this concept of chromosomes and its packaging.
Let's go back just briefly to the fact that we have in each cell 46 chromosomes. These come 23 from mother and 23 from father.
All right, Mr. Goldberg, I'm sorry, can we just have you, Mr. Goldberg, could you give Mr. Neufeld that seat there, please, and slide over a little? All right, proceed.
To make a very simplistic drawing of a cell, you have the nucleus somewhere in the middle, which contains the 46 chromosomes. The rest of the cell on the outside is referred to as cytoplasm. And just as fast as I write this down, you don't really need to know or remember this. We're just going to focus on the DNA that's in the nucleus. People who are expert at looking at chromosomes under a microscope can distinguish the 46 chromosomes as pairs because they stain slightly differently if you put a dye on them, and they have somewhat different shapes. So we'll just make a crude drawing here of a chromosome pair, and someone who is expert at this could actually say, well, this is chromosome pair number 1, and the pairs are numbered 1 through 23 and very well characterized. So to look at it under a microscope, if I could find each of the 2 chromosome number 1s, I couldn't tell which came from mother and which came from father by looking at them, but we'll just, in my example here, say that this first one came from the father and the second one came from the mother. Now, if you think of the chromosome as the packaging of the DNA, if you unwind the DNA from the chromosome, for each one, you would have a very long thread. And the best analogy that I can give to you is that it's not very different from going and having a spool of thread, and the spool of thread has dimensions that are maybe an inch high and an inch in diameter or something. But if you unwind that thread, it's many yards long. And in the same way, if you unpackage the DNA from each individual chromosome, it would be very, very long. And my drawing isn't at all in proportion. If I had chromosomes that were this size and I unpackaged the DNA, it might be several stories worth of length. So it's a very long thread. If we then look closer at the DNA, we see that each strand is actually what's referred to as being double-stranded. And if we did this for an entire cell, rather than having just 2 chromosomes, as I've shown here, you'd have 46. So you'd have 46 long strands of DNA if you were able to unravel each chromosome and lay out each piece of DNA.
First of all, is this entire molecule of DNA, first of all, is DNA a molecule?
Yes.
Is this entire molecule the same in every cell of our bodies?
Yes.
In terms of this concept of chromosomes, if DNA were a book, would a chromosome be something like a chapter to the book?
Yeah, that's it.
Okay. Now you've introduced this idea of two strands. What do you mean by two strands to DNA?
You mean these two that I've drawn close together?
Yes.
We might want to go to an additional diagram to try to illustrate that better than I could draw it here.
All right, a diagram of a ladder of DNA.
Yes.
All right, very good. Your Honor, this second chart, would the court prefer to have it marked People's Exhibit 236 since the
Yes.
witness went to a second page?
Yes, 236.
All right. All right, I think we have a prepared diagram, Your Honor, that I'd ask be marked People's Exhibit 237.
All right, diagram 237. How about right there for the time being?
You know, while we're waiting for the next one, can you show the ones that are already done to council? Would you rather we wait?
Hold on. We have a break coming up in 10 minutes, so we'll do the other exhibition at the break.
Your Honor, for the record, this chart could be identified as labeled at the top with DNA and depicting what appears to be a ladder
All right,
with
Mr.
various
Grumman,
notations.
Could you raise that up, please? All right, thank you. Mr. Byron.
Thank you, Your Honor. Dr. Cotton, with respect to this diagram that's been marked People's Exhibit 237, can you describe for the jury, please, what it shows? And we have pointers right at your left hand there, if that would help.
This thing?
Okay.
Or shorter than.
Okay. DNA is two strands wound together to in a helical formation. And the reason I didn't try and draw it on my drawing here, I just do two strands side by side because I can't draw this shape very well. But the two strands are wrapped around as if you took two ribbons and twisted them one around the other. DNA has four basic components. They are referred to as bases, spelled B-A-S-E-S. So there are four bases that make up all the DNA, and they have the names adenine, guanine, thymine, and cytosine. And they are abbreviated A just by their first letter, A, T, G, and C. These four bases are the DNA alphabet. They exist along the length of the DNA molecule in a specific order. And that order has meaning to the cell. And it's just like if you look at the English alphabet, it has 26 letters, and you can put those letters together to make words, which in turn make sentences, which in turn make paragraphs. The order of these four bases or four components on the DNA has meaning to the cell, and that order is translated into information that the cell can use. The other important, or another important feature is that these four components or bases come in pairs. Along one strand, you'll have some particular order. So this order is first a G, then an A, then another G, a T, a C, and a T. Always across from a G, there is a C. So people talk about a base GC being one kind of base pair. Always across from a T is an A. So in the DNA, there are two kinds of base pairs, an AT pair or a GC pair. They are paired together like that, and the pairing is very specific because in the structure of the molecule, this distance from one strand to the other strand is constant. And if you add up the distance that a C takes, or the space that a C takes up, and you add up the space that a G takes up, it's always the same, and it is the same as the space that an AT pair takes up. So if you can think of it as if you had a zipper, but you had four different shaped teeth, and the zipper would only come together when every A was paired with a T and every G was paired with a every G was paired with a C.
Would it then be correct that if a G was paired with an A, that it simply wouldn't match or stick together?
Well, if there was a single mismatch like that, then it would be very loose there. But you can't have a lot of mismatches or the two strands won't stay together.
Incidentally, this structure of DNA, as you've described it, when was it discovered?
The structure was discovered and published in 1953 by Watson and Crick.
Is that Dr. Watson and Dr. Crick?
It's Dr. Watson and Dr. Crick, and I believe that the article was published in 1950.
So a little over 40 years ago.
Yes.
As far as this diagram, and it shows these A's and T's that match at least in 3 instances, and then it looks like 3 more instances where the G's and the C's match. Is this simply a small portion of an entire segment or an entire molecule of DNA?
A very small portion. There are altogether 6 billion base pairs. And this is, of course, an approximation, but in human beings, you would have 6 billion base pairs of information. One of the important things to note from this diagram is that when people talk about DNA, you can talk about DNA as being a particular length. It is possible to get a physical measurement of the length, but that's not the common way that it's discussed. Scientists talk about DNA in terms of how many base pairs long a particular piece of DNA is. So the particular piece of DNA that's on this diagram is 1, 2, 3, 4, 5, 6 base pairs in length. And you can discuss DNA, and it is discussed in terms of how many base pairs long is a particular piece.
When you describe the entire molecule being roughly 6 billion bases, is that in each cell of our bodies that has a nucleus?
Yes.
And in terms of the cells of our bodies that have a nucleus, is that all cells?
No. That is almost all cells, and the major exception, or the only exception that I commonly would refer to, in fact, I'm not sure if there are others or not, is red blood cells. And red blood cells, in the development and the formation of a red blood cell, the nucleus is lost, and there is no nucleus in a red blood cell. So if one were to get DNA from blood, the DNA is not coming from the red blood cells, it's coming from the white blood cells.
While we're on that topic, can you describe, please, what are the various sources of DNA? In other words, various parts of the body that DNA can be taken from.
Well, DNA can be taken from almost any source. You can get DNA from bone, from any tissue, liver, spleen, pancreas, kidney, brain, skin, if you have enough blood, semen, hair roots, not the part of the hair that you're washing and combing is just protein. If you pull out a hair and you get the hair follicle with it, there are cells around that hair that are part of that hair follicle, and they contain DNA.
When you use the term follicle, is that the bulb-like material at the very bottom of a hair?
Yes.
All right. As far as this structure, and you've described on this chart the fact that DNA is shown here in a double-stranded form.
Yes.
Does DNA also, or can it exist in a single-stranded form?
It can be made to be single-stranded. It occasionally, in the process of making 2 cells out of a single cell, will exist for short stretches in single-stranded form, but that's, again, something we really don't need to be worried about.
And we're not going to worry about that today because we're done. We're done with OJ. We're going to go back to our regular lives and we're going to get ready to hear her riveting testimony on DNA tomorrow. Today's the 15th, tomorrow's 16th. I will not be streaming on the 18th. I'm going to take a day off. I haven't had a day off in a while, so relax, people. I hope you guys have a great day, though. I really do. I'll see you all again really soon. Bye, guys. Thank you so much.